So our final snippet for this week looks at just a couple of kind of cleanup issues from the constitutional history during the Roosevelt administration, which we covered a lot in our synchronous session on Monday, but there are two themes that I want to mention. First, you might remember I mentioned this really weird case dealing with evaporated milk, and the backdrop to this was. I'll admit I've never used evaporated milk, but this was relatively common during the Depression. And so the evaporated milk industry hires a lobbyist to go to Congress and get Congress to pass a law listing the specifics of what constitutes evaporated milk, because there were competitors that were using a slightly different formula that allowed them to undersell the sort of standard evaporated milk companies. And the law basically said that those challenging companies couldn't describe their product as evaporated milk, which in turn hurt their sales. And as a result, those companies sued, alleging various violations of the Constitution. And that issue made it to the Supreme Court in 1938 in this case called United States versus Caroline Products, which did two important things. So the first is that the court says that it's going to presume constitutionality when Congress passes a law dealing with economic regulation, which sets a very, very high bar for challengers to win. And then there is a footnote to the decision, which I mentioned in class when we were talking about Korematsu, footnote 4, and the key passage here is this passage in red, which envisions a more searching judicial inquiry, which comes to be known as strict scrutiny, when you have a law targeting particular religious, national, or racial minorities. And that's this tiered approach to constitutional challenges, which has been in place since 1938 and which continues to govern U.S. constitutional law. And the Caroline Products theory, which is that basically the court should okay any economic reform law, is solidified in this case called Wickard versus Filburn, 1942. It deals with agricultural policy, but the key passage here is the conflicts of economic interest between the regulated and those who advantage by it are wisely left under our system to resolution by the Congress under its more flexible and responsive legislative process. So think back in class when we were looking at that Atkins decision, or back even further, the Lochner decision. What the court is saying here is that court should simply not, federal courts should simply not strike down legislation dealing with economic issues. And it will not be again until 1995 that the Supreme Court strikes down any law dealing with economic or Commerce Clause-based regulation, which is something it routinely did during the 1900s, 19-teens, and especially in the 1920s. So this is a major shift in the Supreme Court during the late 30s and early 40s. They're basically saying we're not going to rule for challengers, business interests usually, who want to strike down congressional legislation dealing with economic regulations, and basically don't even try to bring the matter to court. The second other theme from the Roosevelt administration is this debate over executive power in foreign affairs, including the war-making power. And this is a major, major theme in U.S. history and in thinking about the Constitution in the run-up to World War II. And the backdrop to this is that by the mid-1930s, there is a consensus in the United States that the entry into World War I was a mistake, that Woodrow Wilson had been manipulated by arms manufacturers and by bankers to bring the U.S. into the war to bail out the British and the French, that the war was not in the U.S. national interest, that Congress's power had been weakened. And so Congress tries to seize back that power, to limit the executive's authority in international affairs. In a law called the Neutrality Act, which was passed in 1935. Its chief sponsor is this man, Gerald Nye, who was a Republican senator from North Dakota, a liberal Republican, which basically says, when a war breaks out, the U.S. should avoid becoming involved even commercially. Americans should stay out of it. There should be no American trade. It should be embargoed. The fear is that unless you do that, the U.S. will get pulled into the war like it did with World War I. Ironically, the first use of the Neutrality Act deals with this just bizarre war between Bolivia and Paraguay from 1935 to 1938 called the Chaco War. It's a dispute over the western half of Paraguay. Bolivia and Paraguay had been the big losers in major wars in South America in the 19th century. Bolivia once had access to the sea in what's now northern Chile. They lose a war called the War of the Pacific, where they simultaneously fight Peru and Chile seizes this area, which turns out to be really, really important because there's copper deposits in it. So Chilean prosperity in the 20th century comes from this war. And Paraguay loses a war in the 1860s called the War of the Triple Alliance, where they simultaneously fight Brazil, Argentina, and the newly formed state of Uruguay. You don't need to be a strategic genius to figure out that this tiny country fighting Brazil, Argentina, and Uruguay simultaneously is not going to fare well, and they do not. Just massive casualties during the war. So these two countries they're the only landlocked countries in South America. They're commercially weaker than most of the other countries in the region, and there's a sense that there may be valuable mineral deposits, perhaps oil, in the Chaco, and that's what triggers the war, which ultimately Paraguay wins. But for our purposes, the key aspect is FDR says, all right, there's a war going on. We're going to enforce the Embargo Act. We're not going to come in. This is a photograph of the fighting area. This is the Chaco in the 1930s. This is a Bolivian tank. This is not a high-tech war. And American war manufacturers challenge FDR's decision on the embargo, and it works its way up to the Supreme Court in this very, very important case dealing with executive authority in international affairs called U.S. v. Curtis Wright Export. And this is the same court that Roosevelt is feuding with on domestic matters, but on international affairs, in this critical decision, the court says the president alone has the power to speak or listen as a representative of the nation. He makes treaties with the advice of the Senate, but he alone negotiates. Into the field of negotiation, the Senate cannot intrude, and Congress itself is powerless to invade it. So the court says, look, the president has made this determination in his capacity as commander-in-chief in charge of U.S. diplomacy. We are not going to second-guess the president. And one of the key themes of constitutional history and international affairs after World War II is this tremendous growth of presidential power and diminution of congressional power. And the irony is that this comes, Curtis Wright decision comes from the passage of a law, the Neutrality Act, which was designed to reclaim congressional power in international affairs. And FDR, in the run-up to World War II, uses that power repeatedly. He recognizes that the U.S. basically needs Britain to win the war. So he negotiates by executive agreement a trade whereby the U.S. sends older naval destroyers to Britain who desperately needed them. And in exchange, the U.S. is granted temporary leases over British bases in Jamaica, in the Bahamas, in Bermuda, in some of the Caribbean British colonies as well. And FDR even goes to a meeting here in Newfoundland, Canada, with Prime Minister Churchill, where they discuss common war aims before the U.S. has even entered into World War II. And this is sort of an aggressive application of Curtis Wright. And Roosevelt basically says, look, I'm the president. I have this authority. FDR also persuades Congress to pass a law called the Lend Lease Act, which allows for the United States to send military aid to any country resisting the Axis, which in 1941 is primarily Great Britain, the Soviet Union. FDR controversially provides them with aid. Australia, a British colony, but a key factor in the Pacific War, and to a much lesser extent, China. FDR doesn't see China as a significant military force in the region. But the Germans and the Japanese, unsurprisingly, see the U.S., even though they're not formally involved in the war, as in effect participating in the war. Roosevelt's policy generates substantial opposition in the United States. Remember, there's still this sense that U.S. was wrong to enter World War I. And while Hitler is never particularly popular in the United States, opposition to the war is, and Hitler does have, sadly, pockets of support. The most powerful opposition anti-war movement is this group called the America First Committee, probably the most powerful foreign policy lobbying group, grassroots lobbying group in American history up until that time, which is chaired by this man, Charles Lindbergh, the famous aviator who goes to Europe in the 1930s and kind of is wowed by Hitler, but also sees the war effort as wrong. Lindbergh kind of drifts to the right in the 1930s, although his father was a very left-wing anti-war congressman from Minnesota, so he kind of brings that approach to him as well. This is, Lindbergh is charismatic. He's a celebrity, and his arguments against the war carry great weight. This is a photograph of an America First rally just about at the time of the Pearl Harbor attacks. It's only with Pearl Harbor that America First disperses. And there is an attempt to rein, an unsuccessful attempt to rein in executive power by using the Constitution through the amendment process, focused on the activities of this man, Lewis Ludlow, so Democratic congressman from Indiana, who proposes what's known as the Ludlow Amendment, which is to amend how war is declared in the United States. Ludlow argues that the president has simply become far too powerful, and the Ludlow Amendment would have created a system called a war plebiscite. So before the United States could enter a war, unless American soil was attacked, before the United States could enter a war, there would have to be a national plebiscite. And if a majority of Americans voted for war, then the U.S. could get in, otherwise not. Congress never approves the Ludlow Amendment, so it never becomes part of the Constitution, but it's a reminder in the run-up to World War II, along with the America First Committee, that there was real resistance in the public to FDR's dramatic expansion of presidential power in national security affairs, and this is something that periodically resurfaces in post-World War II history as well. So that's all we have for this week for the snippets. I hope everyone is staying safe, and I will see you all on Monday. Okay, bye-bye.